would not be the first case, because aside from this one on Moses Kulal, I beg your pardon, Moses Lenol Kulal, we had the one on Muthomi Njuki, the charges he was facing, 35 million shillings in irregular procurement, the charges read, but were withdrawn by the DPP. And then we have the Oparanya case that proved contentious during the vetting exercise. This conflict between the Ethics and Anti-Corruption Commission and the office of the DPP, what would be your recommendation, your expert advice in resolving it?
I think what I may consider as an unhealthy tension, which is also unnecessary, between EACC and the DPP. The Constitution reserves the power to prosecute exclusively to the DPP, which means the decision to charge, that call ultimately belongs to the DPP, and the person who takes responsibility for that decision is the DPP, and therefore it's not part of courtesy and committee between officers for EACC to impugn improper motive or some bad intention on the part of the DPP when these charges are being withdrawn. Because in any event, Olive, if EACC, because usually when the DPP proposes to withdraw charges, I'm not holding his brief, but I say this as someone who has practice experience in this court. When the DPP proposes to terminate charges against any accused person, the DPP usually furnishes reasons. And I've had occasion to look at some of those reasons. Usually they range from gaps in the evidentiary material, and they direct DCI or the investigating agency, if it was EACC, to close those gaps. I have had experience before where I've seen EACC insisting that they have done the best they can do and that the case should proceed as is. The DPP reiterating that as is not tenable, and if someone loses this case, the person who bears accountability for losing corruption cases is always the DPP. So I think if the EACC requires or hopes that they want to be given powers to prosecute, let them say so directly. At the moment, the back on the decision to charge, to continue with those charges, to terminate those charges, belongs to the DPP or stops with the DPP, and there cannot be an unhealthy tension where one investigative agency, such as the EACC, routinely impugns improper motive on the part of the DPP. Because again, Olive, that could have unintended consequences, such as eroding public confidence in the office of the ODPP. If the EACC feels that, yes, we've heard you, and no, we're not challenging the mandate of the DPP, we're saying that in this particular case, we believe the DPP is mistaken in the law, then that proposition or that position that contradicts and conflicts the DPP's position will naturally be picked by the trial court, because the trial court will question, why are you terminating these cases? And if the trial court is not satisfied, the court will order that the case proceeds. So I don't think it is safe to say DPP terminates corruption-related charges for ulterior motive or to serve unexplained or undisclosed collateral interests.
All right.